Good morning. My name is Jack Lavin, President and CEO of the Chicagoland Chamber of Commerce. Thank you all for joining us today. I would like to welcome you to this informative virtual event on recent changes to Illinois' equal pay concerning new reporting requirements on employers. With us today are guest speakers from the distinguished firm and proud member of the Chamber, Cozen O'Connor, as well as staff from the Illinois Department of Labor. We are thrilled to have a panel of thought leaders on this important topic today, including Sydney Holman, Principal, Cozen O'Connor Public Strategies, Jeremy Glenn, Office Managing Partner at Cozen O'Connor, Brittany Green, Labor and Employment Specialist at Cozen O'Connor, and Jason Keller, Assistant Director, Illinois Department of Labor. Thank you all for being here today and sharing your expertise with our chamber members. In January of last year, the Illinois General Assembly passed and Governor Pritzker signed significant changes to the Illinois Equal Pay Act designed to strengthen protections against wage discrimination in the workplace through the creation of a new Equal Pay Registration Certificate. After a series of negotiated fixes and delays in implementation, the new requirements finally became effective in the spring of this year. Given the fact that these recent changes impact Illinois employers in every sector and of almost all sizes of companies, we hope this program helps you understand how this new law came about, better understand the new Equal Pay Registration Certificate reporting process, and hear directly from the Illinois Department of Labor regarding resources available to employers. Throughout the presentation, please feel free to submit any questions you may have via the chat function, and we will be sure to get to them at the end of the program during the moderated Q&A section of this webinar. And as a disclaimer, I would like to clarify that any information or content provided on this webinar is meant for general information purposes only and is not intended to constitute legal advice. Viewers are encouraged to retain legal counsel with respect to any particular legal matter. Thank you again for being here. And with that, I'd like to begin the program by kicking it over to Sydney Holman, Principal at Cozen O'Connor Public Strategies, and her team to start off the program. Sydney?
Good afternoon, everyone. Thank you so much for joining us today. As Jack said, I'm Sydney Holman from Cozen O'Connor Public Strategies. I handle the government relations and the strategic partnerships in the firm. I'm going to kind of give you all a little bit of legislative background and history as to why this law came about. For those who may or may not have followed, the revision to the Equal Pay Act or accumulation of two specific pieces of legislation, Senate Bill 1480 and Senate Bill 1847. This is kind of modeled off of the California Equal Pay Certificate law, which passed in 2019. The Illinois Black Caucus decided to kind of mimic that law by making it applicable for all Illinois employers with 100 or more employees to file equal pay certificates to the Department of Labor. In the beginning, I understand why it may seem daunting and overwhelming for businesses, but this could really be a blessing in disguise, in that it gives businesses and companies the opportunity to proactively internally review their employees' wages by race, obviously considering factors such as seniority, education level, and specific position requirements and skill level for a specified wage. This kind of helps companies to just privately and internally review for any hints of discrepancies and the opportunity to rectify those issues before they speak to the department. This also gives businesses the opportunity to maybe seek outside counsel or help with DEI entities or legal counsel to kind of help them with some of their issues. And in this law, we understand that companies, as they kind of go through, they're going to notice that maybe they have a minority pipeline challenge, or they're having issues hiring diverse applicants for specified roles in different industries. So we know that that's going to be an issue, and I think we hope this webinar will kind of help provide some recommendations for that. So with that said, I'll kind of turn it over to the lovely people at Cozen O'Connor Public Strategies. They're going to go through the legal meat of the law and hopefully provide legal recommendations for companies who are kind of struggling and don't really know where to start. So thank you all, and I will go ahead and turn it over to Jeremy and Brittany. Thank you.
Oh, thank you, Sydney. And hello, everybody. My name's Jeremy Glenn. I'm a labor and employment lawyer at Cozen O'Connor here in Chicago. And I've been doing this for about 25 years, advising businesses of all sizes, from 5 to 5,000 employees. And I have to say that this is one of the most progressive and ambitious equal pay laws in the country. There is no doubt that it is founded on a principle of fairness and compensation based on race and gender, and that is a laudable goal. And every employer is well served to make sure that its compensation decisions are based on factors that are legitimate, performance, education, service based. So with that being said, Ramiro, if you could go to the next slide. These amendments to the Equal Pay Act, I think, require a business that has 100 employees or more to start right now. We know that around about 1,000 businesses in Illinois have already received the letter asking them to prepare the application for the Equal Pay Registration Certificate. But if you have 100 employees or more, your time will come. And in fact, over the course of the next year and 9 months, every business is required to submit this application. So let's start now, thinking about what's required, what information we need, and how we're going to submit that application. And I would encourage you, talk to your friends in the business world about this. The Chicagoland Chamber of Commerce is an excellent resource. But if a business misses the window to submit their application, and they should have done so, there will be financial penalties. So this is an area where the more we talk about it and the more we are aware that it's coming, the better served we are. Next slide, please, Ramiro. Let's start with the simple concept. Private employers that already file an EEO-1 report with the federal government on an annual basis and have more than 100 employees in Illinois must apply for and obtain an equal pay registration certificate from the Illinois Department of Labor. Sounds simple, right? You're going to apply for a certificate of equal pay compliance, and the Department of Labor will issue that to you. Well, first question is, are you covered by the law, right? If you file an EEO-1 statement, which has been a requirement under federal law for decades, then that's pretty easy to know you're going to be on the list for the Illinois Department of Labor certificate program. If you have 100 employees, you may have to count them carefully. And with the COVID pandemic, more people are working remotely than ever before. Brittany will talk about what it means to be an employee in Illinois covered by this law in just a few minutes. But the point I want to leave you with, I strongly encourage everyone who knows they fall into these categories to make sure that you are registered with the Illinois Department of Labor. On the website, there is a link to the enrollment form, and that allows you to give contact information to the department so that when they send the letter notifying you that you have 120 days to comply, they don't send it to an empty drawer or an old email box or someone who's departed from the company. Because ultimately, the compliance obligation is on the employer, not on the department, to make sure they send to the right person. So I strongly encourage you, go to the Illinois Department of Labor website and register your business and provide contact information. Next slide, please, Ramiro. When you receive a letter from the Illinois Department of Labor, it will give you 120 days to submit your application. And what do you submit? Well, three things, really. You pay a fee, $150. You submit wage and demographic information for Illinois-based employees. And then you sign a certificate that says, we are in compliance with the equal pay and non-discrimination laws. We as a business certify that the average compensation for female and minority employees is not consistently below the average compensation for male and non-minority employees within each major job category in the EEO-1 report, taking into account various factors. And then there are 3 or 4 other aspects of the certification. How do you determine pay? Do you correct pay discrepancies when you see them? And do you provide equal employment opportunity without regard to sex, race, or other protected categories? Sounds simple, right? Well, as we know with most regulations, most laws, there's a whole lot of detail to unpack. When you submit the wage and demographic information, the Department of Labor has provided templates that tell you what information to collect. I would encourage everyone to take a look at your current data, whether it's your human resources information system or some other database, to see if you have already collected race, demographic, address, job title, and wage information about your employees. Next slide, please, Ramiro. Here's an important slide with 2 links to the websites from the Department of Labor, where you can find the template sheet. It's a spreadsheet that tells you what categories of information are required. And you can find an example of the certification that you'll be required to sign within 120 days of receiving the letter from the Department of Labor. On this website, you'll also find frequently asked questions. And I commend the department for providing some guidance to those of us who are trying to figure out what the law means. Another recent addition is proposed regulations have come out from the Illinois Department of Labor. And those too are helpful in clarifying some parts of your certificate submission process. So Brittany, I wonder if I could ask you to talk about a couple of the highlights from the proposed regulations and help our audience understand what they mean.
Yes, you can. Hi, everyone. My name is Brittany Green. I am a labor and employment attorney here at Cozen O'Connor. I grew up in the southwest suburbs of Chicago, and I attended Loyola University Chicago for both college and law school. So very pleased to be with you all today. I did want to share some information about the proposed regulations issued by the Department of Labor related to the equal pay certificate process. So as some of you may know, the Department of Labor did publish these proposed rules on May 20th, 2022. And fortunately, they do attempt to clarify a lot of the questions we have surrounding the Act. So we're briefly going to go over some of those most key clarifications today. So let's start with the definition of employees. With the large transition into remote work over the course of the pandemic, there were lots of questions surrounding how to determine whether a business has 100 or more employees within the state of Illinois, and under what circumstances do we count remote employees. So these proposed regulations clarify that the definition of employee means any person performing a service for a business under the Act whose base of operations or the place from which the service is directed or controlled is located within the state of Illinois, or whose base operations or the place from which the service is directed or controlled is not in any state in which some part of the service is performed, but the individual's residence is in the state of Illinois. So that's still a lot, but at the least, we do know that this proposed rule clarifies that the law not only covers employees based at a business's physical location in Illinois, but also employees who work remotely outside of Illinois, whose work is directed or controlled within Illinois, and remote employees working within Illinois, whose work is controlled or based outside of Illinois. Another area of clarification that we received from the proposed regulations involves good faith errors and corrections in the application. So there was lots of confusion surrounding the logistics of the law, and businesses have been concerned with the $10,000 penalty associated with these requirements, despite making good faith efforts. So luckily, we did receive some clarity as to what is considered a good faith effort when complying with certification requirements. So the regulations define a good faith effort to comply with the certification requirements as demonstrable efforts by the business to promote pay equity and combat employment discrimination, including but not limited to internal compensation reviews, staff training, adoption of equal pay opportunity policies, and evidence these policies were enforced through evaluation, investigation, and personnel action. It is still important to note that the regulations do impose an obligation to correct any mistakes in a company's application for certification. So to correct information, businesses need to send the department a revised application with correct and complete information, along with a letter identifying that the information, what information was actually amended. So if this is done, the proposed regulations make clear that the business won't be subject to penalties if the incorrect or incomplete information was provided in good faith and without knowledge that it was incorrect. And the proposed regulations now also have a detailed procedure for an employer to appeal a rejected application. So under the proposed regulations, employers have only 14 days to appeal a statement of rejection. So that also needs to be done as well. We've also received questions about who signs the equal pay compliance statement, particularly who should be the authorized agent signing the statement and certifying that the company is in compliance with not only the Illinois Equal Pay Act, but the Federal Equal Pay Act, the Illinois Human Rights Act, and Title VII. So the proposed rules define an authorized agent as an employee of the business with knowledge of pay practices, who has been designated by the corporate officers of the business to submit information to the Department of Labor. So we now know that this individual does in fact have to be an employee. The authorized agent does not include any outside legal counsel, outside consultants, or vendors who serve the business. So all of these proposed regulations go through a notice and comment period, and the regulations might change a little bit when the final regulations are published, but we do anticipate that the final regulations will look similar to the proposal. There is a public hearing regarding these proposed regulations on August 9th, 2022. So if you want more information on this hearing and the proposed rules, all of this is available on the Illinois Department of Labor website. So stay tuned. And with that, I'll turn it back over to Jeremy.
Indeed, we will stay tuned, right? This is a developing area, and I would imagine for most of you on this call, you've not yet received your letter. So I want to remind you again, make sure that your current contact information has been provided to the Department of Labor, and that's available on the websites here. Ramiro, next slide, please. You will see when it comes time to submit the requested information that it includes things like the job class, the ethnicity, the race, the job title, first name and last name. But we know that pay can be influenced by a lot of different factors. So I would encourage every business to think about what factors, what elements really do impact pay at your company. Is it something like length of service, where there are annual increases? Is it something like educational requirements for a job or licenses? Is there something unique about the working conditions? Are there more hazardous spots than others? What about training? What about a collective bargaining agreement that might set wages regardless of race or gender? I encourage every business to think about those elements, because if they're part of what drives your compensation, I would strongly recommend you submit it along with the wage information to the department. Because the law specifically says that your certification is about average pay, taking into account the factors like these, which are not based on race or age. So strongly recommend that every employer think about what things impact the compensation that our employees receive. Next slide, please, Ramiro. And in fact, this won't surprise you to hear from a lawyer, but while you think about what factors do that, I strongly encourage you to think about doing a pay audit. I think before you sign a certificate swearing that your compensation is equal, you need to know if it is or not. So before you submit the certification application, I think you need to look at your pay data based on employee and location and race and gender and all those other factors to see if there are issues of disparity that can't be explained by any legitimate factor. And if you work with legal counsel, we can take steps to adjust those things. And ultimately that serves the overarching goal that Sydney described at the beginning, which is to eliminate pay differences that have nothing to do with skills, education, experience, or performance on the job. if your company has 150 employees, it may be a little bit easier to analyze your data than a company that has 3,000 employees. So think carefully about calling your trusted employment lawyer or Brittany and I. We can help you work with the pay equity professionals who give you good insight into your data and then can take steps to correct it if those are necessary. Ramiro, next slide, please. This has the contact information for Brittany and I, and of course, you can find us on the web at cozen.com, and we're happy to be a resource to the Chamber and its members. And with that, it's my great pleasure to turn it over to Jason Keller, Assistant Director at the Illinois Department of Labor. Jason is a fantastic speaker. He is a wealth of information, and I'm so pleased that you're here with us today. Jason, thanks for joining us.
Hey, thank you very much. And I think it's still morning, so I'll say good morning. I joined a little bit late, so hopefully I won't repeat anything too much, but I do want to say Jeremy and Brittany did a phenomenal job in laying out portions of the act and the rules. So I will simply try to run through some high-level stuff and walk you through how we have approached implementation and how we continue to approach implementation. With that, if we can start the slide deck. And maybe go to the next one. There we go. So as I think you probably heard, the public acts that are controlling the implementation of these provisions are Public Act 101-656 and Public Act 102-36, basically establishing that businesses that have 100 employees or more in the private sector and also file an EEO-1 must file pay information with us. The Public Act states that the business that is subject to the act has 2 years to obtain an equal pay registration certificate from the department and must recertify every 2 years to obtain a new certificate. Next slide, please. I won't go over this in great detail, but if you want to look a little bit, this is basically how we approached it early on as the legislation was moving through. We did work with the Illinois Manufacturers Association, the Illinois Chamber of Commerce, and the Illinois Retail Merchants Association in trying to get connections with businesses throughout the state that would be subject to this act. The highest hurdle that we had to overcome early on is that we did not have any contact information for the businesses subject to this act. And so it was very difficult to notify employers that they needed to comply with these provisions. So we utilized their communication networks, and we also worked with Data Axle, a vendor here that captures public body and business information to reach out to those businesses. Next slide. So again, the new amendments state that businesses subject to the act must register with the department between March 24th, 2022 and March 23rd, 2024, and every 2 years after. We again got the contact information from the businesses that went on our website to do so. We got the total list of employers, and we essentially divided that list up into 8 parts. And it was done completely randomly because I know because I did it. I couldn't tell you one business or another is where they are located within that time frame. And so it's in 8 parts. It basically represents the 4 quarters in each year. And so what we have done is assigned each of those parts a registration date deadline. And the department then sends notification out to those businesses that this is your deadline to register with us. And then we also provide 4 trainings each quarter for those businesses that have a deadline coming up to show them how to interact and interface with our portal and provide us the information. Next slide. So I think some of this has already been covered, but I'll cover it here real quickly. In addition to the EEO-1 form that we asked for, businesses are required to file the following with our department: a compiled list of all employees during the past calendar year. So right now in 2022, we are asking for 2021 data. It's got to be separated by gender, race, and ethnicity categories. We ask for the county in which the employee is working, the date the employee started working for the business, and the total wages paid to each employee. I will state one of the hurdles that we have come up against is that employees obviously move within a business, they get promoted or change positions. And so we're working actively to educate employers on how we want it listed when they provide that information to us. Essentially, we are asking if an employee moves within their organization or gets promoted, that you separate it into 2 lines of information by job title, and effectively letting us know the end date of the old position. So that's how we have advised folks. The new Public Act allows the department to ask for any other information it deems necessary to determine if pay equity exists. At this point, we have not made any changes to the information we have requested. The department will provide a template Excel form for businesses, which is on our website as well, that you can easily download. Next slide. Again, here are the registration dates that we have outlined. So we've gotten through our first 2, and we obviously here in September have the 3rd registration due date. We are preparing to notify the December 12th registration tier. We try to provide 120 days advance notice to each tier. So we will be sending those notices out around August 12th. That's what we're going to shoot for. So that will be going out here very soon. As I think Jeremy mentioned, many businesses have not heard from us yet, and we tell people that you may not hear from us until the end of 2023, but we will be contacting them, notifying them of the registration due date. I can stop for a second if people, oh, okay, that's fine. I just want to let people jot those dates down if necessary. I'll give it another 5 seconds and then we can move forward. I think both Jeremy and Brittany maybe have alluded to this. This is the equal pay compliance statement that the businesses have to submit, basically an affidavit or certification saying that the business is in compliance with the Equal Pay Act of 2003, and then the Title VII of the Civil Rights Act of 1964, Illinois Human Rights Act, the Equal Pay Act of 1963, and the Equal Wage Act. And they'll have to certify that the average compensation for its female and minority employees is not consistently below the average compensation as determined by the Bureau of Labor Statistics. The business does not restrict employees of one sex to certain job classifications and makes retention and promotion decisions without regard to gender. That wage and benefit disparities are corrected when identified to ensure compliance with the acts cited above. You have to tell us how often wages and benefits are evaluated. The approach the business takes in determining what level of wages and benefits to pay its employees. That could be take the form of a collective bargaining agreement. It could be seniority. It could be prevailing wages, you name it, but we would like to know how you evaluate that or determine it. And lastly, the template statement is on our website as well for you to review and look over. Next slide. So what does the department do with this information? Any individually identifiable information submitted to the department is considered confidential and not subject to FOIA. Individually identifiable information means data submitted pursuant to this act is associated with a specific person or business. We can aggregate data and produce reports based on the volume of information we are getting in. And we can list the job category and average hourly wage by county for each gender, race, and ethnicity category. The decision to issue, not issue, revoke, or suspend an equal pay registration certificate is public information. A current employee, this is one of the reasons the law was basically set up, is basically that a current employee of a business may request, this is a hard word, anonymized data from the department about their job title and pay for that classification. So basically, if they want to know if they're getting paid fairly or equally to other people that worked in that job title over the past 10 years, they can request that data from us. We may share data and identifiable information with the Department of Human Rights and Office of Attorney General if we feel there's possible violation. There are penalties for any department employee who willfully divulges this information as well. And that was crucial from the business community. They wanted to protect that data. Next slide. This is the contact information regarding enforcement of this act. If you have any questions, again, I think I said this, but I'll say it one more time. We preach compliance over being punitive in this manner. So please reach out to us with any questions and we will be more than happy to help in a timely manner. And I just want to say thank you for allowing me to present before the group as well. Very much.
Great. Thank you, Jason. Thank you for joining us. It's great to see you again. And thanks to all the panelists for this great information. We do have in the chat box, if you have any questions, we've already got some questions from members, but if anyone else has any questions, we'll work to get through them. But I also want to say this is a really important topic. You know, we know that this is going to be, it's a new law, so it's going to take time to comply. And we have some great experts from on the government side with Jason, and then certainly Cozen O'Connor and them to give us some information. But let's just start out with some questions for all the panelists. I know there's been changes from the initial version of the legislation to the current law. The threshold of 100 or more employees, I think that may have changed. But I also think it's worth one more time just clarifying what employees fall under this. I'll take example, a chamber member during the pandemic, one of their employees was based in Chicago. They were working remotely and they moved to Nashville. And no one even knew they moved. But they're still primarily, their home office is Chicago, but they're working out of Nashville. I think this is a good question. What employees, just clarify what employees come under this act, and any changes that have come in the law over the last several months are working through implementation.
I'll take that question if Jeremy wants to help fill it in as well. We did seek clarification, and it was very minor, just to make sure it was clear that any business with 100 or more employees were subject to the act. There, you know, some people were saying, well, what if I have 100, do I count? And we want to make clear, yes, if you have 100 or more, you do count. So we did seek that clarification. And as Mr. Lavin alludes, we have taken that question regarding remote employees many times, and we've tried to be consistent with our answer. Basically, if the employee is reporting to a physical office location in Illinois, and when we say reporting, we mean that's where their supervisor is based, or that's kind of where their payroll goes out of, they should be reported on the list that's submitted to us, if that helps clarify.
Yep. So I've told clients, if you had people move across the border into southern Wisconsin or into northwest Indiana, or if they found a home elsewhere, but they still take direction from the Illinois location, then they count. And full-time, part-time employees, we're looking at how many employees did you have in the last calendar year, right? So if you get your letter in 22, you're looking how many employees did you have as of December 31st, 2021? And if it's 100 or 101 or higher, then the certification process applies, and those people are going to end up on a spreadsheet submitted to the department.
What if you're a part-time employee?
We would ask that you still include part-time employees as well.
So that would count in the 100 if it's full and part-time employees.
That's how we have advised, yes.
And Jack, I might follow up on that. That again goes to this idea that every business is different. And on its face, if you simply told the department that employee A made this amount in wages last year and employee B made that amount in wages last year, and they have the same job title and the same EEO code, but different race and gender, if the pay is different, that needs to be explained. So these additional factors like how many hours a week did the person work? How many total hours a year did the person report and get paid for? Those are the kinds of thoughts you need to put into the data, because you may want to submit more data to explain what on its face looks like a difference in pay.
But does the form allow for that, or do you have to put that in? If you know what I'm saying. Let's say I primarily have hourly employees and some work 30 hours, some work 50 hours. Is there in the form, does that allow for explanation like that, or do you have to write that in?
In the form, no. The way we developed it, we really wanted to keep it as simple as possible, so it wasn't businesses have enough paperwork to fill out, and we recognize that. So we really wanted to keep the fields very limited. In the course of implementing this, however, we have encountered people want to explain any discrepancies. So what we've allowed is for them to, if they want to put on a Word document, explain any discrepancies and upload that to us to explain those differences.
And how many companies in Illinois do we think are covered by this? 100 or more employees?
I'll give you kind of a rounded up estimate. I think it's about 6,000 that we have. There may be more, but that's what we have contact information for. So. Right.
Great. And have you staffed up to cover all this after you started getting these certificates in?
We did get an appropriation. We are in the process of hiring up. Yes.
Great. And what, this is for all the panelists and including Jason, obviously, but have there been any issues? I know it's just started, but the current process and getting contact information and, kind of as this is being implemented that have popped up that you see to let companies know or, to be in compliance.
I mean, that's a fairly
like
broad.
the top issues, like we started this in the spring and we're starting to implement it, and here we're seeing some issues that we just want to let you know and be aware of.
I mean, basically just start early with filling out the forms. I wouldn't wait for necessarily the due date. That was one thing that we had at our last registration due date, is we had a glut of businesses file at the very end, and it kind of gummed up our system a little bit, but everyone got through. And then we have a certain amount of time to respond. I guess that's what I would really recommend, is if you can not wait until the very end, and then we can work with you if there's anything that needs to be fixed prior to us giving you a certificate.
And how do you, I would imagine there's a lot of mid-sized businesses, some of the bigger corporations have an HR department. A lot of mid-sized businesses, they just have their heads down and they're trying to stay ahead of the pandemic and keep their business growing. How besides us, chambers and others, how are we getting the word out to them? What other ways are you getting the word out to them?
We've issued a number of press releases and done quite a few interviews to try to get the word out, but primarily, trying to get the contact information and work with business partners, doing other webinars like this, just trying to get to help communicate these matters is very beneficial. And that's, again, our biggest hurdle is just reaching out and finding those businesses that are subject to the act.
And Jack, one of the points I made earlier is that the onus really is on the business to apply for the certificate before March 23rd of 2024. So I would encourage every business to put a tickler on at the latest January 1st of 2024. And if you haven't heard, be mindful of the fact that that final deadline is approaching. And I suspect, despite all of its best outreach efforts, March 23rd of 2024 will be a heavy data submission date for the department.
Yes, it will be.
Yeah, and obviously why we're doing it today, we want to continue to partner with you to get the word out, because you don't want this to be a gotcha. You don't want to be, I just was never aware of it. And so we want to continue partnering with you, and as not just today, but as we move towards that deadline, working with you, the Department of Labor, and of course with firms like Cozen O'Connor to get the word out. So we'll continue, and this will be on our website, and we'll continue to have communication with our members. I guess this is for Cozen. What sorts of methods are employers using to make sure that they're rectifying any possible discrepancies within their own workforce?
Yeah, right. So the method starts with what we call a pay equity study. And that is literally collecting data by job title, job class, individual, and determining if there are any factors that explain why one person might be paid $5,000 more than another. So the first thing is to look at the data to identify, is there a difference, despite what on its face should be two people making the same amount? And then once you have exhausted the legitimate factors that might explain that difference, if you can't do so, then the method is back pay and bringing a person up to the current compensation rates. These are difficult choices, and they differ from every business, but almost always it involves creating an equality in the pay structure that when it can't be explained by any legitimate factor. And that usually means bringing those who are underpaid up to a higher level. And we know the labor market is difficult right now. And so competition for talent is fierce out there. And any employer that's paying attention to its compensation factors and the market knows that this kind of internal study can have beneficial results in terms of hiring and attracting and retaining talent as well.
Yeah, what have been the top challenges so far you've identified for companies?
The top challenge is identifying the factors that explain a difference in pay. And oftentimes that means diving deeply into, for example, the location of the individual's work. So we know the data asks for the county in which the person works. Let's say the person works in Cook County. We know that throughout the county, there are differences in wages based on, is the place of employment in a high-rise building in the Loop, or is the place of employment in a smaller location in suburban Cook County? So it might be that the employer needs to dive deep to understand, is this person getting paid less because of the place within the county that they work?
So how about I have an employee, they walk into my office and say, I got another job offer for a 30% pay increase. Can you match it? Maybe not, but let's say you might. And does that mean I got to give everybody a 30% raise?
That's a great question. There would be a dozen different factors that go into it. But it does raise some concerns. Yes, if all of a sudden you've got an outlier in a job category whose pay is higher than others in the category, despite the same responsibilities, skill, effort, and qualifications, yes, that could be problematic.
Yeah, I mean, these are anecdotal stories we hear from members with the competition for talent now, that people are walking in the door saying, I got another offer. So, I mean, I think that's just one of the challenges that will be out there. And Jason, of course, Illinois is trying to get companies to move here all the time. We've got big companies like Kellogg, Google's expanding. But what about, some of these mid-sized companies that are coming here and we don't always see them and they may not yet be members of the chamber? How are we going to how are we going to handle that? How are we going to get in touch with those companies and make sure they're aware of this new law?
Again, we will work with anyone and everyone to promote this law. It's something that we strongly believe in. And I think you guys just touched upon one of the main reasons it was implemented was to ask businesses to make these evaluations on how they pay employees. And I think that was the intent of the General Assembly when they passed it, is to actively think through that process. That being said, we are trying to do more community engagement as well. We're hiring an external affairs person here very soon. And so we will be out in the community and trying to show everyone the laws we enforce and inform people of those laws. We will continue to produce press releases regarding this law and do any external interviews that we can as well.
Yeah, the penalties can be pretty high on this. How are you looking at what is a good faith effort? How are you defining that?
I think we're looking very softly on this at this point. I mean, we're still within the first year of implementation and really, again, preaching education on this law before we reach out and penalize anyone. That being said, if someone is going to thumb their nose at us, we will proceed accordingly, though.
What's been the history of equal pay complaints for employees in recent years, and what do you expect when you start getting all this data to find out and maybe new issues come up?
The history, I mean, it was passed obviously in 2002 and then begun implementation in 2003. When it was first implemented, it was actually the Illinois Chamber, I recall, because I was working on Senate staff at the time, wanted the comparison to be done by county, and that was a fair amendment to that bill as it was passed. So we look on a county by county basis accordingly in similar job titles. Can you repeat the second part of your question? I'm sorry.
But just, like, what do you expect to learn something new which may impact? There may be a reason that pops up of why there's a differential. As Jeremy's covered a whole bunch in his presentation, something else may pop up, or something may pop up that we have to tighten up things. So I'm just, if you have any ideas of what you expect as the data comes in.
Yeah, I think we have begun looking at some of the data in aggregate, and I think there is a great amount of disparity between the highest, let's say, white male salary versus the highest African American male salary. I think you'll notice, again, men and women, a huge disparity between the highest paid salaries in the state. And so that may be something that we highlight in any reports going forward.
If I may, Jack, I think Sydney alluded at the beginning to the value that businesses may see from this effort. I also am optimistic that a year or two from now, a company will be able to proudly say, we have a certificate from the Illinois Department of Labor confirming our equal pay strategy and compliance. And if a talented applicant is evaluating two different businesses, maybe that becomes a question during the interview process. And the applicant says, I'm proud to work for a company that has the certificate. So if we can work together to create a streamlined, efficient way of reporting the data, then perhaps that certificate will be a prideful banner going forward.
And I would imagine that as these pay audits are happening, you may just find something that you weren't aware of in your hiring process and your wage analysis process, and that can help the company. That's something they just may not be aware of.
Absolutely, yes. In my experience with equal pay compliance in the last 20 years, it's almost never an intentional decision to pay someone less because of their race or gender. It's it's a lack of attention to creep that happens over time. And there can be timing impacts. If the market is very strong for applicants, then pay might go up. But did you address the incumbents who stayed with the company? So yes, I agree. It's seldom an intentional act. It's more often just, we couldn't get to it because we were dealing with the pandemic and we were dealing with 100 other issues facing our business.
Also, hi, this is Cindy. I'd just like to elaborate a little bit on that point. In working with the Illinois Black Caucus on this law, I think this audit and this legislation is going to just kind of open the eyes to the lack of minority pipeline. For example, you may be a science, a biomedical research company, and so you have very few people of color who are the actual scientists and the managing directors, but you may have more people of color who are more so the secretaries, and that's where you do see a lot of discrepancy. And so I think this is also going to help companies maybe work with their industry counterparts and figuring out how we can fix this, how we can get more Black scientists, how we can get more, African American or Latino or, Asian accounting experts. So I think it's really going to kind of make some of the companies be more proactive and really understand that there's this pipeline issue. And I think a lot of companies really struggle with that pipeline issue. So I think it's going to force us to be kind of more creative in how we address those problems.
And for the Cozen people, let's say you go and do an audit and the company had creep and they weren't aware of things, and all of a sudden you tell them, hey, you got this issue and you got to change it, and they say, hey, our margins, we're losing money, and you're telling me I got to adjust all this pay. What do I do? I mean, what if it's dramatic? How can they do it from just a business standpoint that they want to comply, but there's an immediate shock?
That's a great question, Jack. And the recognition of a pay disparity that cannot be explained by any other factor should be addressed, because as we know from every area of the law, it's worse to know about a problem than ignore it than to not know. So a company needs to go into the audit with eyes wide open, that if adjustments need to be made, we're going to need a strategy to do that. And one strategy may be, we can't address it right now, but we are going to chronologically address it over a number of pay periods, or we're going to address it in a quarterly approach. But at least we're going to be aware of it, and we're going to plan a method to get into compliance. Even if you can't the next day open up the checking account and correct everything right that moment, at least a strategy to do so over a short period of time is advisable.
Going off that point, I do think that goes to the heart of the legislation, to get businesses to be more proactive about these issues as opposed to just sitting on them. So hopefully this becomes part of their regular practice, and it'll be less shocking over time as well.
Well, we've pretty much just run out of time. I don't know if anybody has any concluding comment that you want to make that follow up to a question or a point we didn't reach. Just give a moment for that.
Hi, just to make a few last comments before I turn it over. I understand some entities are going to have some issues specifically at the audits. They may see that they may not have any people of color in their workplace, but I definitely would suggest they, start partnering with some of the universities. Specifically, you have SIUE, you have University of Illinois, you have Chicago State, you have Illinois State, you have a lot of state universities, and public and private actually, who already have hubs for minority and women talent. So I think that may be a great start to help kind of fill those gaps, in addition to potentially hiring a diversity and equity and inclusion coordinator, or working with the entity that already has one. And I think as you start the conversation, this is going to become easier and companies will be able to adapt correctly over time. So I think that would be a good place to start as well.
And my concluding remark, Jack, would be a reminder to enroll and make sure the department has contact information. If you know you're in the 100 employee category, do it now. As Jason said, they've already divided up and scheduled notice letters. So don't be afraid that registering today means you get a letter tomorrow.
That's correct.
At least you'll get it sometime over the next year and a half.
And I'll conclude my remarks with, as Jack asked, how are we going to promote this further? If any of those on the call wish us to appear on a similar webinar, we will certainly do so. We'll accept just about any invitation to come and educate people about these new provisions and to promote the act.
Great. Well, thank you again to our speakers for being with us, Sydney Holman, Jeremy Glenn, Brittany Green of with Cozen O'Connor, and the Assistant Director of Labor for the Illinois Department of Labor, Jason Keller. We really appreciate you taking the time out of your busy schedules and having really such a productive discussion this morning. And there'll be more to come, because I'm sure as we get to the deadline, we'll need to continue to inform people. I also want to thank Ramiro Hernandez. You've heard his name behind the scenes. He's part of the Chamber's government relations team and helped put this whole thing together. So thank you, Ramiro. I also want to thank all the Chamber members in attendance today and for being here and for your continued support, which allows us to hold such vital and topical events such as this. If you're not a member, thought leadership programs like today's webinar, advocacy, and connections to grow your network and grow your business are the foundations of what the Chamber provides for our members. Please contact us and we'll provide you with all the information on the benefits of membership. This webinar was recorded and it will be on our website, so it is available. Please tell any other member companies about this and tell them we have it on our Chicagolandchamber.org website. And thank you all again for joining us today, and enjoy the rest of your day. Thank you again.